Hello and welcome to this seminar on financial remedy after Covid-19. My name's Elizabeth Nicholls and I'm a barrister at Regency Chambers. Firstly, I'll just talk about the financial impacts of Covid-19. We're all aware of the lockdown which occurred on the 23rd of March 2020. This was on instruction by the government. There were only 4 reasons for leaving the home. We've also seen that occur across the whole of the world to try and stop the spread of Covid-19. What's resulted is that the global economy is estimated to retract about 25%. We're effectively in a self-induced recession. UK unemployment rates are set to double to approximately 9%, and the UK economy is estimated to retract around 14%, 25% in the second quarter of 2020. This is the deepest recession in 300 years. Now turning to the people impacts of Covid-19. Firstly, we saw panic buying. Those were acts of self-preservation, people purchasing bulky items, some of which they then resold on the internet, making profits. But what are the psychological impacts of quarantine? Stress, anxiety, depression, and as you can see on the right-hand side, the coverage in the media, mental health impact of lockdown may be seen for many years. Half of UK workers are feeling more stressed and anxious during lockdown. The schools are closed, they have children at home, they're schooling children at home, and they don't have any childcare provision. What are the physical effects of quarantine? Well, these are 24-hour restrictions. There's been an increase in domestic violence, and this is the perfect environment for marital feuding. So what's been the impact on the courts? Guidance has been published, the Remote Access Family Court by Mr Justice MacDonald. It's now in its 4th version. First appointments are now an accelerated paper-only procedure wherever possible, and judges are being accepted to accept consent orders. In terms of FDR, we're seeing an increase in private FDR remotely where possible, and all hearings should be physical hearings only when absolutely necessary. And as per the guidance, a remote hearing is likely to be consistent with the interests of justice. Physical documents and court bundles need to be submitted by email, so we're all working in a very different environment. What's the longer term impact on the courts? Well, the family courts are already stretched, as we know. In the light of Covid-19, numerous cases are being adjourned. The most urgent cases are quite rightly being prioritised, and those capacity issues are increasing. There are some cases deemed unsuitable for remote hearings, and they have to be rediarised at a time when we believe we may be physically back in court. But ultimately, financial cases are taking longer than we expect. That's only adding further uncertainty and increasing stress and anxiety for clients, but also court staff. In terms of new applications, there's been a predicted surge of applications after Covid-19, which I'll refer to. There may be a backlog of applications as online becomes more accessible, and the courts may be struggling with the resources in post-Covid-19 world. So what's the impact on our clients? I'll refer to 2 groups of clients in this seminar, those who are considering divorce and those who are recently divorced. For couples who are considering divorce, the stress of lockdown has been reported globally. That's put financial stresses and strains on couples. They're in close confinement with each other, and there's been a reported spike in online applications. If you look at what the press is reporting on the right-hand side, there is a surge in divorce anticipated, and China have already seen divorce rates rise as couples emerge from their coronavirus quarantine. The question really then arises, can couples actually afford it? They've lost their employment, they're facing financial uncertainty, and for some couples that may mean postponement to another date. Some couples have seen reconciliation. They've made up for lost time together during their quarantine, and they've reignited their relationship. So will we actually see more divorce and financial remedy cases? Well, a study by the University of Washington in 2016 collates 14 years of data. As you can see on the right-hand side of the graph, there are 2 spikes. Those are starting in January and in July, and after the Christmas period, after the summer holidays, when couples are spending more time together, that's when the spikes really start. So will there be a 3rd spike? Well, the evidence suggests that there will be. So for couples considering divorce, they're potentially facing long delays. There's also uncertainty of asset values due to the volatile market conditions. The question really arises, do they have finances to proceed with financial remedy proceedings at all? I can only hypothesise at this stage what may actually happen. So for recently divorced couples then, as you can see on the right hand side, coronavirus has affected UK property sales. They've hit record lows in April this year. You don't have to have a multi-million pound financial remedy case to have a significant asset. It's mainly in the property. Property shares and pensions have experienced some loss of value now, but there is also potential loss of value in the future. Shares specifically have reduced in the main, however there are a few out there which have flourished. Dignity plc is a group of funeral directors. They've increased 9%, and we've all seen Amazon's success as people turn to online deliveries during Covid-19. The UK property market, the transactions were actually lower than the 2008 and 9 financial crisis. Estate agents have been closed. They are now reopening and viewings are taking place, but making use of technology. These are often virtual tours. So a question then arises, can transfer and sale of property orders actually be completed? Looking specifically into property, the Lloyds Banking Group, which incorporates Bank of Scotland and Halifax, predicts that property prices will fall 5% in 2020. That is going to be significant for some. Shares, pensions, investments will all be affected, and if you look at the graph on the right hand side, which shows the rise and fall of the FTSE 100, on the 31st of March 2020, that was a significant dip. These factors will affect ability to pay and possibly complete transactions. The value of assets have reduced, and the uncertainty of asset value has therefore increased. Maintenance agreements may not be able to be paid. Some have experienced loss of income. They might not be afford to pay at all, and the affordability of those agreements may be linked to performance of shares and market conditions. So what are the factors affecting asset values post-Covid-19? Interest rates. These are the lowest ever recorded at 0.1%. They are making property more affordable, but lenders are being more cautious. Employment is a significant factor. Wages and bonuses have been reduced. That's resulted in a reduction in income and household cash. The number of people in employment has been reduced and businesses are greatly affected. Valuations are a factor also affecting asset values. Physical valuations haven't been taking place. Those have been online and sometimes they're less comparable. Investments such as shares, bonds, foreign currency and foreign property may also be important. Pensions, market investments, they're all linked to the stock market. They have also fallen. So the question then arises, what about reopening of an order? These are the orders that can be varied by the court. Maintenance pending suit and interim maintenance, lump sums by instalments, deferred lump sums, pension sharing orders before decree absolute, provision for children and sale of property. So what will the court actually consider? Well, under section 31(7) of the Matrimonial Causes Act, the court will consider all the circumstances of the case. The court can consider the case afresh, and we get that from Flavel and Flavel. The court is not restricted to considering changes in matter taken into account when making of the original order. Well, what about consent orders? Well, Joy Marancho and Joy tells us that an order made by consent may not usually be varied unless there is a change in circumstances. We also know from case law that needs are a dominant factor. Miller and McFarlane and Mills, but specifically in Mills, we learned that the payer is not expected to meet the needs if it's as a result of the recipient's financial mismanagement. So looking to set aside. An application to set aside can be made on very narrow grounds. 1. Non-disclosure of material evidence. There's a duty of full and frank disclosure in proceedings. 2. Fraud. For example, deliberate misrepresentation of asset size. 3. Lack of capacity, mental health issues. And 4. Events occurring after an order is made. Now, a case that we have heard in recent events has been Barder and Barder. Now, just in brief, on the right-hand side, is a tragic case where the wife killed the children and committed suicide 5 weeks after the consent order was made. The House of Lords held that the husband could appeal out of time. The basis on which the order has been made was invalidated. Now, in Barda and Barda, there are 4 factors which need to be satisfied for a Barda event to have occurred. The House of Lords said that subsequent events must invalidate the basis on which the order was made. Events must have occurred within a relatively short time of the order, and an application to set aside must be made promptly. But importantly, the granting of an application should not prejudice third-party rights, and that's, for example, a bona fide purchaser of property. In terms of the legal principle, the financial court order may be challenged in certain circumstances. It allows the court to exercise its discretion to grant leave to appeal out of time. But the question arises, is Covid-19 really a Barda event? Well, Nassim and Nassim was a Barda event. The wife, in the original order, had an unequal split of the matrimonial home of 70%. That was on the basis that the children would spend significantly more time with her than the husband. 6 weeks later, an event occurred, and the children went to live with the father 100% of the time. That was deemed by the court a Barda event. But we're looking specifically into changes in asset values post-Covid-19. Property prices have fallen, shares have taken significant dips, and other assets have been affected. In Cornick and Cornick, Lady Hale said there were 3 possible causes of change in asset values. 1. Correctly valued asset at the time, but the changes in value had occurred in a short time as a result of natural price fluctuation, and that would not justify setting an order aside, as it would vary a capital order. 2. There was an incorrect value put upon the asset at the hearing. If it had been known at the time, it would have led to a different order. That was a genuine mistake, and it was open to the court to give leave to reopen the order. 3. Something unforeseen and unforeseeable happened since the date of the hearing, which has altered the asset value. That resulted in a substantial change in the balance of assets. Crucially, it's unforeseen and unforeseeable, and it's open to the court to give leave to open the order. In Meyerson and Meyerson, the couple reached an agreement at FDR. The wife was to receive 43% of the assets, the husband 57%. The husband's share consisted of significant business shares which fell dramatically. They then resulted to amounting to 14% of the assets. The Court of Appeal held that the case fell into the first category of Cornick. It was just a natural price fluctuation. They said the natural process of price fluctuation, whether in houses, shares or any other property, and however dramatic, do not satisfy the Barda test. In Walton and Walton the same year, a shareholding dramatically increased in value. The Court of Appeal again held this fell into the first category of the test in Cornick. It was a natural price fluctuation and therefore did not satisfy the Barda test. So will Covid-19 be a Barda event? It will be on a case-by-case basis. It's very fact-specific and cases are rare. Courts, of course, will be wanting to avoid floodgates. It's a global pandemic, which is an unforeseeable event and has huge lasting impacts. In terms of significant effects, it may result in the death of a party, and there may be a significant change in asset values. But really the question is, at what point does Covid-19 become foreseeable? And that's going to be very fact-specific in terms of timing. So this chart shows the steps to set aside and vary a financial order. Step 1 should be to discuss with the other party to vary the terms of the agreement. Happily, if you can reach an agreement, you have consent. However, if there is no agreement, you need to apply to the court to vary and set aside due to an unforeseen change. This is an unforeseen change in circumstances which undermines the agreement that's been reached. Then step 3 is the hearing, and then hopefully a new order. This chart shows steps to convert heads of agreement, possibly at FDR, and this may be a common occurrence. Number 1, discuss with the other party to vary the terms of agreement and reach an agreement in order to gain consent. The other party may say no. There's a significant change occurred and I don't want to be held to the heads of agreement. So then an application needs to be made to the court for an order within the terms of agreement. That's to enforce the heads of agreement. And that's a notice to show why the other party should not be held to the terms of the agreement and convert it into a final consent order. So just some things to keep in mind. Asset values. There is a prediction that some house prices may fall. The Lloyds Banking Group, which incorporates Bank of Scotland and the Halifax, say that these may fall 5%. That's significant. Some people might be looking for a change of scenery. They're comparing the city versus the country. With more and more working from home, they might be able to work more flexibly in the future, this resulting in going to the city maybe 1 day a week instead of 5 days a week. There may also be less buyers and lenders are more cautious. There's less certainty generally about everybody's financial future. In terms of a stock market revival, that's merely hypothesis at this stage. There are several predictions of which recovery curve may be followed. Stocks and shares and pension valuations throughout the process may need to be updated, and we've all heard the phrase, past performance is no indication of the future. So what will happen in terms of financial remedy caseload? We've heard that divorce and financial remedy applications are likely to increase. We're likely to see a short-term post-Covid-19 spike. Online accessibility of households increase and access to court forms. In the UK, you can apply for a divorce online. You can see on the right-hand side, HM Courts and Tribunal Service say it makes it more convenient for you. That may result in increased direct access inquiries. Clients may be managing part of their own process. Alternatively, they may say, I've got too much to deal with in my life right now. I want someone else to take care of everything for me. Some couples may very well decide to postpone their proceedings. They're going to put it on hold until a time of more certainty. They might be waiting for the dust to settle, and a time of more financial certainty may mean that those proceedings come back. Some may be experiencing reconciliation. Mediation and counselling will increase, and requests to terminate proceedings may occur. So when will the courts be back up and running? Well, there's no clear indication when the courts will actually resume, and we're unsure what back to normal actually means. Criminal courts may also need space for their jury trials, and there has been some rumours in the press that sports halls may be used for family cases as our criminal counterpart take over proceedings. Online hearings may actually be the new norm. You can see on the right-hand side just a snippet from the media, but we've all seen these types of screens in our working lives right now. Some proceedings may be more suited to these types of online proceedings. They may be considered as more cost-effective and more efficient. We will see an inevitable backlog of cases. There are busy times ahead, and the court staff and judges will be working with an ever-increased workload. We have in recent days seen revised versions of court orders, directions and also financial orders, and those are to be implemented from the 6th of July, and you can find those on the Judiciary website. So in summary, the long-term effects of post-Covid-19 are unclear. What we do know is that there's been some effect on asset values, and we'll proceed to see those effect on asset values in the future. Property, shares, pensions and investments are certainly ones to watch. Updated evaluations and valuations may be needed as part of an ongoing review in proceedings. With regards to orders already made, firstly try to agree with the other side, otherwise an application to vary or set aside may be necessary. As to barter events, there'll be a very small amount of cases. There will be a limited time period, and they are rare. The case law of 2008 and 2009 financial crisis tells us that was not a barter event, but Covid-19 may be different, very, very fact specific on our clients' cases. What we do believe is that new cases are predicted to spike post-Covid-19, and a re-evaluation of those assets during the process will be necessary. Any further changes can be captured, ensuring the best outcome for our clients. So thank you very much for your attention and listening to my seminar today. If you've got any questions, please forward those to the email address on the screen. Thank you very much.